Thank you, Clarissa. Good evening, ladies and gentlemen, and good evening to all of those who are. I'm looking at the computer. I don't know if that makes any difference. I just had a look through the list. I scrolled through the list of those people who are registered to watch online, so I know who you are. I know where you are. And I say good evening to those of you who I know well, particularly a few of you up there in Toowoomba. Thank you for checking in and participating in the seminar, albeit from a distance. Now, a couple of months ago, I think I was talking to Clarissa about Twilight seminars, and
Regan says hi from Toowoomba.
It occurred to me, or it came to me that the idea of talking about caveats would be a good one, particularly having regard to some of the developments I was involved in earlier this year in respect of the case that I decided. Some of you know, some of you may be there on night, some of you I know a copy of the paper, but I gave a paper called Application in Family Law, Property Settlement Disputes. As long ago now as nearly 10 years ago, 2005. And in fact, when I indicated I was going to speak to caveats, two people sent copies they keep it in their bottom drawer. In fact, I couldn't my original copy on Word, so I had to print out a copy of one of the ones that I think it was Trent Waller sent me, and get my associate, poor thing, to copy type it out again. So on Sunday, I went into my chambers, brought it up, and simply amended it where necessary. So those of you, and my written paper that I have prepared, which I simply added to today's date, I'll send through to Flipper tomorrow, and it'll be attached to, or will be now uploaded to the Flipper website, including the relevant sections of the Land Title Act, including relevant drafts of draft caveats that you might like to use, etc., etc. So will be on the website and available. I'm sorry I don't have a PowerPoint presentation. I usually like doing PowerPoints. It distracts me from actually reading the paper, and when you see it, it gives you a cue just to talk. But I haven't had a chance to prepare a PowerPoint. So the subject, I know, as I say, some of you will have been here, some of you will have read my paper. Some of those who I've already spoken to this evening, who are more senior and experienced practitioners who had a copy of my paper, that they're glad in a way that we're revisiting the subject, because in their experience, a lot of practitioners, particularly in the family law area, don't properly understand caveats. So who wasn't there in 2005 when I gave the paper, and who hasn't read my paper? So, okay, well, hopefully you'll all learn something. The proper understanding and use of caveats is a seriously good tool for the family law practitioner. And indeed, the proper understanding of caveats is probably an even better tool for the family law practitioner who's defending the registration of a caveat, wanting to actually get rid of it off a title. So I urge you all, if you are at any stage considering using a caveat, or if you've got a client that comes in confronted with the registration of a caveat on a property that they don't like, to familiarise yourself very carefully with the provisions of Part 7, Division 2 of the Queensland Land Title Act. That's sections 121 through to 131 of the Land Title Act. That's the part that deals with caveats. Section 124 of the Land Title Act is in fact the section that makes a caveat a statutory injunction by preventing the registration of an instrument that affects the lot over on the caveat as the caveat's date and time of lodgement. Caveat becomes effectively a statutory injunction, having that effect until it either lapses or is cancelled, as it's rejected by the registrar, or removed or withdrawn. To say in my paper, family lawyers confront the caveat issue usually early in the process of providing advice and representation, when emotions of their respective clients are running high, when protective or reactive steps may be required as a matter of urgency, and sometimes when the completeness and accuracy of instructions can be doubtful. The consequences of making mistakes in respect to caveats and their lodgement can be quite devastating though. But in addition, the tactical advantage that can be gained for a client at this stage certainly require you to understand and know how to do it. Of course, you would already appreciate that the caveat will generally be considered or confronted by the family lawyer in circumstances where one member of a couple is the sole registered proprietor of a piece of real property, and the other member of the couple fears the registered proprietor will dispose of or deal with his or her interest in that piece of real property to the prejudice of the non-registered proprietor after their relationship's broken down. Miriam Matthew urged me when I walked in to stress this, and I told her that I have in my paper, and I've even marked here that I've written on there this afternoon. I wrote on there, this is a critical point to stress. And it's a one-sentence paragraph in my paper, early in the paper. You must always remember that a claim for a property adjustment order pursuant to Section 79 or Section 90 SM, the de facto relationship of the Family Law Act, is not a caveatable interest. Never has been, and until the Act is amended to say that it is, it never will be. Section 122 of the Land Title Act sets out who may lodge a caveat, and that list of people includes a person who's claiming an interest in a lot. It also includes a person who already has the benefit of an order of an Australian court restraining a registered proprietor from dealing with the lot. So if you go to the court and get an injunction restraining the person from dealing with it, well then you can just go and use that injunction, that order, to put on a caveat. That might be considered to be the safest way to get a caveat onto a property, having regard to the potential pitfalls. Now, if you're relying on the benefit of an injunction already granted, then depositing an office copy of the relevant court order when the caveat is lodged will ensure that the caveat does not lapse. And avoiding or stopping a caveat from lapsing is very important. That's something you've always got to be aware of. If you're not relying on having the benefit of an injunction that's already granted, then Section 121 2F of the Land Title Act requires that a caveat must state the interest claimed by the caveator. Section 36 of the Act Interpretation Act defines interest to mean a legal or equitable estate in land or other property, and I highlight here for family law purposes, equitable estate in land or other property, or B, a right, power or privilege over or in relation to land or other property. Quite clearly and fundamentally, equitable interests in property can coexist alongside what has been described as the inchoate interests which arise under Section 79 or nowadays as well Section 90 SM of the Family Law Act. Married couples, de facto partners can indeed have equitable interest in property determined in accordance with equitable principle, and they exist and sit well and truly alongside a right to bring an application for property adjustment orders. However, they are distinct from that right. It's beyond the intended scope of my paper to enter into a detailed discussion of the law of equity and its application to disputes. Practitioners, most of you, although I'm not so sure whether the younger ones would be, but most practitioners would be aware of the equitable remedies available in the form of implied or resulting determined to exist in circumstances where partners contributed to the purchase of property in shares not reflected in their holding of the legal interests therein, and constructive trusts, those that are variously determined to exist in circumstances of common intention, unjust enrichment, or unconscionable conduct. Now, in the 90s, family law practitioners dealing in de facto relationships knew all about constructive trusts that arose through unconscionable conduct. We would call them Baumgartner-style constructive trusts. I hope law students who have come through since then, also solicitors and barristers who have done law since then, certainly nevertheless learned about Baumgartner-style constructive trusts. The thing is that these days, with the conferral on parties to a de facto relationship of the right, statutory right, to seek property adjustment orders under Section 90SM, the number of people relying on equitable remedies in property disputes, particularly Baumgartner-style constructive trusts, has virtually dried up to zero. But the existence of those equitable remedies still importantly provide the basis of supporting your caveat. Section 121 requires that the grounds on which the interest is claimed are stated by the caveator. I said in my paper in 2005 that anecdotal evidence suggested the registrar usually rejects caveats where the only equitable interest claimed was an equitable interest arising on a Baumgartner-style constructive trust. The registrar took the view, apparently in those days, that the equitable interest under that type of trust doesn't exist until it's declared by the court. In contrast, though, equitable interests arising under implied or resulting trusts or a common intention constructive trust are said to come into existence at the time of the purchase of the relevant property, or at the time that the common intention to share the equitable ownership of the property was formed. So it's critical that the proper attention is paid to the particular type of equitable interest that you're claiming as a caveator and the grounds upon which it's claimed. Experience told me that the registrar usually accepted a caveat where the equitable interest claimed was said to be an interest pursuant to a constructive and or an implied or resulting trust arising upon the contributions of the caveator to the acquisition, conservation and improvement of the property during the course of the relationship of the caveator and the caveatee. As I say, in my precedent documents attached to the paper, you'll see that sort of writing. It's important, really important, that, and I'll come to this a bit more later on, that the grounds that you state in the caveat as the grounds upon which the equitable interest is claimed are the exact same grounds upon which your court proceedings seeking to establish the interest claimed are based. That is, the relief claimed and the pleadings supporting such relief claimed must reflect the grounds claimed in the caveat. It's important that solicitors for caveators always include in the caveat, after the caveator's name, the solicitor's address to ensure that notices of demand from caveatees come directly to the notice of the caveator's solicitors when they're served. That's really important because of the very limited time span within which action must be taken in response to a notice or a request from a caveatee to commence your proceedings to prevent the caveat from lapsing. Section 121(1) of the Land Titles Act requires that the caveat must be signed by or for the caveator. I'll say a little bit more about this later, but be very aware, should a solicitor sign the caveat as the caveator's solicitor, there is a potential for personal liability under Section 130, which provides that, quote, a person who lodges or continues a caveat without reasonable cause must compensate anyone else who suffers loss or damage as a result. Now, in my 2005 paper, I referred to a New Zealand Court of Appeal decision from 20 years ago, called Gordon and Treadwell Stacey Smith, where the Court of Appeal in New Zealand determined that solicitors who'd signed a caveat were liable, concluding that if the Parliament had intended to limit liability to caveators, the term caveator would have been used in the section rather than the words any person. However, a decision of acting Judge of Appeal Justice Young in the New South Wales Supreme Court from, I think, March this year, just earlier this year, called Windlock and Velibor Davidovich and others, 2014 New South Wales Supreme Court cases 269. In that decision, His Honour Justice Young did not consider that the equivalent New South Wales statutory provision was intended to catch solicitors or filing clerks. Nevertheless, I still urge you to exercise care when signing caveats if you're going to sign them instead of getting your caveator client to sign them. Section 123 of the Titles Act mandates that once the registrar has accepted a caveat, he must give written notice of lodgement to each person whose interest or right to registration of an instrument is affected by the caveat. Caveat, of course, can be withdrawn by a caveator at any time, lodging a request for it to be withdrawn. Now, this next part of my paper is probably one of the most important for especially young practitioners. Once the caveat is lodged, what must one do? Once the caveatee is notified of the caveat, Section 126(2) gives him or her the right to serve on the caveator a notice requiring the caveator to start a proceeding in a court of competent jurisdiction to establish the interest claimed under the caveat. Section 126(3) requires that the caveatee notify the registrar of doing that within 14 days of the notice being served on the caveator. Now, if the caveatee serves such a notice, then in order to prevent the caveat from lapsing, the caveator must, mandatorily has to, I'll try to stress that as much as I can, do two things, and they are these. One, must start a proceeding in a court of competent jurisdiction to establish the interest claimed under the caveat within 14 days after the notice is served on the caveator, and two, must notify the registrar within that 14 days, that same 14 days, that a proceeding has been started and identify the proceeding. You don't do either of those things, your caveat goes, you're gone. Failing to do both of those automatically results in the caveat lapsing pursuant to Section 126(4) and 5. So if you're acting for the caveatee, serving such a notice on the caveator as soon as possible after receiving notification of the caveat will put significant pressure on the caveator's solicitors, and from my experience, the barrister who might be involved in having to draw up the proceedings. This is the reason why the drafting of appropriate originating proceedings that seek to establish the interest claimed in the caveat should be attended to as soon as possible after lodging the caveat, if you haven't already done it beforehand. Now, if the caveatee doesn't serve that notice on the caveator, then the caveator still has to do two mandatory things to prevent the caveat from lapsing. They are, one, must start a proceeding in a court of competent jurisdiction to establish the interest claimed under the caveat within 3 months after the lodgement of the caveat. And two, must notify the registrar within that same 3 months that a proceeding has been started and identify the proceeding. Again, failing to do both of those things automatically results in the caveat lapsing. Caveator is taken to have complied with the first of those two mandatory requirements if a proceeding has been started in a court of competent jurisdiction before the caveat was lodged. In such circumstances, the second of the mandatory requirements, that is notifying the registrar within the relevant time and identifying the proceeding, is still necessary. You still have to do that. So the best course in that circumstance is to complete that step at the same time as you lodge the caveat. Completing those steps to ensure that a caveat doesn't lapse, as I've said, is critical. In my experience, the caveator is given no notice of the lapsing of the caveat by the registrar. No such notice is required by the legislation. There's no obligation on the registrar to make his or her own inquiries to determine if proceedings have been commenced. Fraud on the registrar is easily perpetrated by dishonest caveatees. Section 126(7) empowers the registrar to remove a caveat that has lapsed from the freehold land register. The caveatee is then free to deal with the property, perhaps to the prejudice of the lapsed caveator, without any requirement to notify the lapsed caveator. Consequences can be dire. I have personal knowledge and experience in a matter where this happened because of the failure by the caveator's solicitor to give notice that proceedings had been commenced, even though they had, to establish the interest claimed under the caveat. Virtually all that can be done then is to give your appropriate notice to your professional indemnity insurer and send the client off in independent advice. It's clear that a solicitor acting for a client who has a caveatable interest may be liable to an action for damages for professional negligence if he or she fails to advise the client to lodge a caveat. Such problems are so easily avoided. The practice is that where a caveat is lapsed, it will be noted as lapsed when application for lapsing is made by the caveatee or anyone else whose interest in the land is affected by the caveat, and on payment of a lapsing fee. The registrar doesn't have some sort of ring-up system that tells him or her to check whether the caveator has taken the mandatory steps. So actually getting a lapsed caveat removed from the register will require some proactive step by or on behalf of the caveatee. Now, next heading is what proceedings must be commenced. It's important to ensure that the proceedings that are actually commenced are proceedings, one, in a court of competent jurisdiction, and two, that they do seek to establish the interest claimed under the caveat, as I stressed earlier. The obligation on the caveatee when notifying the registrar that proceedings have been commenced, that should be caveator, when notifying the registrar that proceedings have been commenced is to identify the proceeding. Now, I'm aware of requisitions being made by the registrar where the registrar has identified that the proceedings that have been commenced do not actually seek to establish the particular interest claimed under the caveat. I'm aware of a caveat lapsing and being removed by the registrar at the request of the caveatee's solicitors without notice being given to the caveator in the case where the caveatee's solicitors simply drew to the registrar's attention the fact that the proceedings that were commenced didn't actually seek to establish the interest that was claimed under the caveat. Simply, as I said before, commencing proceedings for orders pursuant to Section 79 or 90 SM of the Family Law Act is not sufficient to support a caveat. Should you simply do that, then you run two risks. One, that the caveat will lapse. Two, that the caveatee will make an application pursuant to Section 127 for the caveat to be removed. Caveat to protect a client's interest in proceedings in one of the family courts, claiming an equitable interest by way of constructive trust, then again, to support the caveat, you must commence proceedings that include a claim or a declaration that a constructive trust exists, in addition to the relief that you seek pursuant to Section 79 or 90 SM. You'll all be familiar with Section 78 of the Family Law Act and what it says. In the decision of Hickey, in 2003, the full court said of Section 78, this section empowers the courts to declare existing interest in property according to the general principles of law and equity and to make consequential orders to give effect to the declaration. Section 90, capital F, capital L, is a virtually identical section to Section 78 insofar as de facto relationships and actions relating to them are concerned. So the claim for a declaration that a constructive trust exists, thus conferring an equitable interest on your caveator client, is competently commenced in either of the family courts in reliance upon Section 78 or Section 90 SL of the Family Law Act. If in your application for final orders you seek the necessary Section 78 or 90 SL declaration and consequential orders with respect to the real property that you've caveated, as well as your usual orders for property adjustment pursuant to Section 79 or 90 SM, you should have satisfied the first of the mandatory requirements to support the caveat. Then you must satisfy the second, which is notifying the registrar that those proceedings have been commenced. And you must do that within the time frames that I've already talked about. Should the caveator in a Family Law Act matter not include an application for a declaration under Section 78 or Section 90 SL, then the caveatee respondent has every right to ask the registrar to lapse and remove the caveat. Application to remove a caveat. Section 127 of the Land Title Act says, 1. A caveatee may at any time apply to the Supreme Court for an order that a caveat be removed. 2. The Supreme Court may make the order whether or not the caveator has been served with the application and may make the order on the terms it considers appropriate. Interesting section. State Act confers jurisdiction ostensibly on the Supreme Court. In my 2005 paper, I said that no jurisdiction is conferred by this section on the Family Court. I discussed whether applications could otherwise be brought in the Family Court for the removal of caveats in proceedings between married partners. But things have moved on since then. Earlier this year, I decided an application brought by a company controlled by the property developer husband for a caveat that had been lodged by the wife on a property owned by the company to be removed pursuant to Section 127 of the Land Title Act. Now, in that particular case, I was very fortunate because it was agreed between the barristers who were representing the parties, namely Mr. North, Senior Counsel, leading Mr. Sid Williams, Jr. for the applicant, and Mr. Looney, Queen's Counsel for the respondent, that the Family Court has jurisdiction to deal with the application for the removal of the caveat under Section 127 of the Land Title Act, even though the words say Supreme Court. Now, you might all ask yourselves, how could that be the case? And why would three such barristers agree to that? Well, if you go to my judgment, Mauricio and Mauricio and others, number 2, 2014, Family Court case of 240, I know the cases as a party. You'll see in there that I observed in my reasons, and this is all with the valuable assistance of the three barristers I mentioned in their written submissions, that Section 31, 1A of the Family Law Act gives the court jurisdiction with respect to matters arising under the Act, in respect of which matrimonial causes are instituted or continued under this Act. Then I was able to refer to a paper presented by the Chief Justice of the Federal Court, Justice Alsop, to Family Court Judges Only conference that we had in Melbourne last year, which was called, quote, accrued, unquote, federal jurisdiction and the Family Court. A fantastic paper. I've got a copy of it. I won't put it up on the Flipper website, but if anyone is particularly interested, send me an email and I'll be able to send you a copy. In that paper, Chief Justice Alsop described matter as meaning the justiciable controversy between the actors to it, comprised of the substratum of facts and claims representing or amounting to the dispute or controversy between or among them. It is not the cause or causes of action brought, nor is it the proceedings. Now, some of you may recognise that this is all stuff that relates to what was called, or has been called, or is, if you want to use it in the present tense still, accrued jurisdiction. I think the term accrued jurisdiction will gradually disappear from our language, and that's why, and that was certainly what Chief Justice Alsop was encouraging when he put the word accrued in quotation marks, because it's not the proper way to describe it. It was agreed that the controversy that was before me in that case, in respect of the caveat and the wife's application for an injunction against the company and the husband, arose out of a common substratum of facts, and that they formed part of a single justiciable controversy. I considered that agreement about that issue to be correct. I went on to say, in dealing with the application for the removal of the caveat, and again I've had the benefit of Chief court is exercising federal jurisdiction and, quote, picking up, unquote, and applying Queensland state law where appropriate by Section 79 of the Judiciary Act, the Commonwealth Judiciary Act, 1903. That Section 127 of the Land Title Act refers specifically to the Supreme Court is, quote, and this is a quote from Australian Securities and Investments Commission and Addenda nominees, Chief Justice Gleeson, Justices Gordon and Gummo in their joint judgment from a High Court decision from 2001. Quote, no impediment to the exercise of power by this court, that's the end of the quote, by this court when exercising federal jurisdiction here in Queensland. Just for your interest. I brought along a copy of Section 79 of the 1903 Commonwealth Judiciary Act. And it said, state or territory laws to govern where applicable. Subsection 1, which is the relevant section. The laws of each state, relevantly, including the laws relating to procedure, evidence and the competency of witnesses, shall, except as otherwise provided by the Constitution or the laws of the Commonwealth, be binding on all courts exercising federal jurisdiction in that state or territory in all cases to which they are applicable. Basically, and this is a combination of, this is what Chief Justice also was telling us in his paper, but it's effectively what the High Court, through the number of decisions, has determined. Basically, Section 79 of the Judiciary Act allows us, basically, when we're exercising federal jurisdiction, it allows us to pick up state laws that are applicable and federalise them, effectively. Parties agreed in that particular case also. The agreement was the thing that happened on that day, except they didn't ultimately agree on what the outcome should be. I had to decide that. The parties agreed that in an application to remove the caveat, where the determination is nevertheless being made as part of the exercise of federal jurisdiction, that the onus is still nevertheless on the caveator to satisfy the court of three things. And these arise from Queensland Supreme Court decisions that are cited in my paper. They are, one, that there's a serious question to be tried, which involves showing a sufficient likelihood of success to justify in the circumstances the preservation of the status quo. Two, it's fairly arguable that the caveator has a caveatable interest in the land, and if so, three, the balance of convenience favours the retention of the caveat on the title. Now, in that particular case, I ultimately determined on the evidence that was before me that the caveator wife, even though she'd set out in her caveat the interest that she claimed was virtually in accordance with the precedent to my paper in 2005, that she hadn't satisfied me of all of those three matters. And I ordered the removal of the caveat using what I like to call the federalised Section 127 Land Title Act power conferred in that act on the Supreme Court. For the applicant, through Mr. North, it was submitted that the family court could determine the application simply by the issuing of a mandatory injunction requiring the wife to remove the caveat. Reference was made to a decision of Justice Murphy and Bowen Bateman. Reference was also made to Section 114.3 of the Family Law Act to support that submission. It wasn't argued against by Mr. Looney of Queen's Counsel. He clearly accepted it. That's correct. And so I, of course, also accepted it as correct in those circumstances and made the order in the terms sought by the husband and the second respondent. But if you read my reasons for judgment, I observed in that judgment that I nevertheless also of the view that I could have simply made an order such as is made by the Supreme Court when it determines that a caveat should be removed pursuant to a Section 127 application. I could have simply ordered that the caveat be removed. Such an order is not an injunction directed at the caveator to do all things necessary, but is rather an order that the Queensland Registrar of Titles must act on Section 79, must act on. So it's an order directed at the Registrar, the Queensland Registrar. And I again emphasise Section 79 of the Judiciary Act picks up the power contained within section 127, federalises it, and authorises the exercise of the power by the family court exercising federal jurisdiction. Don't forget, if you bring an application for removal of a caveat under section 127 in family court, that the balance of convenience limb is still an important limb. If there is sufficient property in which the caveator spouse has an interest that cannot be alienated pending the finalisation of the proceedings, and such property, be it solely or jointly owned by the caveator, would be sufficient to protect the overall claim that has been made by that caveator spouse in its best light, then leaving the caveat in place may not be necessary to ensure that a just and equitable property division is ultimately achieved in the proceedings. So on the balance of convenience, you may still be able to argue that the caveat should stay on. I talk about undertaking as to damages in the paper, and I refer back to a paper that Andrew Crowe of Queen's Counsel gave back in 2004 to the bar. The caveator is not subject to the usual undertaking as to damages required of an applicant for an interlocutory injunction, unless the court requires it upon the application for removal. So whether you need that, that's something you have to think about if you're going to bring one of those 127 Land Title Act applications for removal. I talk about cancellation of a caveat in there. I won't go into that just at the moment. You can read about that in the paper. Lodging a second caveat. Where a caveat is lapsed or is withdrawn, cancelled or removed, section 129 allows the person who is the caveator to lodge another caveat for the same property on the same or substantially the same ground, but only with the leave of a court of competent jurisdiction first obtained. So again, I say the same points relating to the jurisdiction of the family court in these matters probably gives the family court jurisdiction if it is a caveat relating to property that is the subject of a dispute in family law act proceedings to consider such an application. That provision basically was included in the Act to prevent a caveator from simply withdrawing and then relodging a caveat every 13 days, as they would otherwise have been able to do without having to commence proceedings, asserting that interest claimed under the caveat. So you just simply can't do that now because of if you lose your caveat or it lapses, you have to apply to a court to be able to put another one on. Finally, really, I'll go to the question that I did mention briefly before, compensation for lodging a caveat without reasonable cause. You have to be aware of section 130. It empowers the court to compensate anyone who suffers loss or damage as a result of a caveat that is lodged or continued without reasonable cause. All clients who want you to lodge a caveat for them should be advised of the possible consequences of this section. However, success in such an action is likely to be reasonably difficult for an aggrieved caveatee. It's necessary to succeed to establish that the caveator did not have an honest belief based on reasonable grounds that it had a caveatable interest, and that the caveator lodged and maintained the caveat for an improper purpose. So there was a decision in the case of Farbert in 1996 about this. Subsection 3 to 130 was added by amendment to section 130 after that, but the subsection places the onus on the caveator to establish reasonable ground, but it doesn't mention the need to establish improper purpose. And the decision in Farbert, in my view, should still be considered good law in those circumstances, and it means it will be very difficult to establish a right to compensation under section 130 because of that requirement for the caveator to have lodged, to be shown to have lodged the caveat for an improper purpose. The person seeking compensation has the onus of establishing it. That's not so hard. Now, in conclusion, depending upon which side of the picket fence you stand on in the context of a marital or de facto property settlement dispute, caveat, once lodged over the title of a piece of real property, is either a drastic fetter upon the right of the registered proprietor spouse to deal with his or her land, or it's a fantastic tool for protecting the rights of the spouse. has no registered interest in that property. Properly used, the provisions, as I started out tonight, saying of Part 7, Division 2 of the Land Title Act are a very effective tactical weapon in property proceedings between spouses or de facto partners. You as a family law practitioner should really develop very quickly, as you possibly can, a specialised knowledge of the use of caveats and those sections that I've been talking about tonight. The practitioner who has that specialised knowledge can gain great advantage for her or his client, whatever side of that picket fence you're on. If they're improperly used and you can show that, they can blow up in the face of an unwary practitioner, and you can gain a great deal of tactical advantage and professional kudos if you can show the person you're against that they don't know anything about caveats, whereas you do. There's absolutely no substitute for a complete understanding of the legislative provisions. You should never try to use a caveat if you don't have that complete understanding. You should never try to properly or to seek to remove one unless you have that complete understanding. So read and reread and consider and properly understand all of those sections of the Land Title Act as soon as you can. If there's any questions, I'll take them.
I think from a young practitioner's point of view, arrives when they get a letter from a hard-hitting commercial lawyer, might be a caveat that affects the interests that suddenly you meet this foreign force called a commercial lawyer who says you take this on.
Or else.
Or you'll face a claim for damage at that stage, I think.
Oh, well, now the young practitioner, you know, as I say, if a thorough understanding is the best means of defence against, you know, some of these gung-ho commercial lawyers. And in that situation, you've now got the benefit of the decision of Justice Young, at least, from New South Wales, to say that he didn't think that solicitors or clerks are in the firing line or should be in the firing line. But if you've done it right in the first place, then you should be able to even stand up to the commercial lawyer. If you haven't, then you might be in a big strike. But so for young practitioners, if they're in any doubt, you know, there's always the senior solicitor in the firm or a young. And I stress this point: young family lawyers, junior family lawyers, should always work very hard at having good mentors who are senior, experienced solicitors or barristers. My experience is that particularly barristers who are starting out at the bar and wanting to develop a practice in family law, those in their first 10 years, some of those who have been family law solicitors for some time before they've gone to the bar, will be very keen to facilitate a relationship with a junior family law solicitor based on, you know, if you've got any problems, any issues you want to talk about, give me a ring. And, you know, I won't, if you just want to run through the wording of a caveat, you know, I won't charge you for that. And you know, have a chat about it and I'll give you advice about it. That thing happens a lot. So, but don't, you know, I again say don't hesitate to get the advice, the proper advice of counsel. That's the situation.
That I was sort of coming to, that it's good to have someone in the face when that arises and that they are around to
Well, there's another, the other very good lesson in that is don't sign the caveat. Don't, because that's where the personal risk can arise. As I say, that New South Wales decision sort of says, you don't need to worry too much about that. And there's those, like I said, there's the decision where the onus is on the person, the KVT who is alleging it was improperly put on to show improper purpose. There'd be a very unlucky junior solicitor who the KVT was able to prove had an improper purpose or is involved in an improper purpose. And in the New Zealand decision that I do quote in there is talk about the solicitors were acting reasonably, having regard to the particular instructions they were given, even if those instructions turned out to be wrong, then they're not going to be in the frame. So,
I think from a practitioner's point of view, the tension arises because the client doesn't always see it as complex. And the client says, client's always cost conscious. And the client wants, why can't we put a caveat on that and put it on here? But I think it's important for the practitioner to see the importance of having someone that they can share it with.
yeah.
And if necessary, disown the client, because if the client's not going to take the advice when you get your excess from full cover, you know, we want this instead.
Yeah. I would like to just, while people are thinking of questions they might like to ask, I'll just go back to that case. I think I said it was called Oricchio, which is the anonymised name, or as a party, but you'll find it as Oricchio. In that particular case, basically the reason why I ordered the removal of the caveat was because at that point in time, no request had been made of the caveator by the caveatee to commence proceedings within the 14 days. It was still within 3 months, and the solicitors who were acting for the wife had not yet commenced proceedings. So there was no suggestion in any application or let alone a statement of claim of the nature of the relief that was being sought. So I could only look at what was in the caveat, which was, like I said to you before, pretty much in accordance with my precedent, equitable interest according to constructive trust, etc. And sadly, I shouldn't necessarily say sadly, but the wife just didn't have enough evidence in her affidavit material to establish that to support an argument that she was going to be able to establish an arguable case at trial. So if you're going to put on a caveat in family law property proceedings, then commence your application, where you seek a Section 78 declaration. Be ready for the other side to say, we want a statement of claim. So you're going to have to draw one of those up, and you're likely to get a judge to say, yeah, that makes sense to me. Because if you read in Oricchio, you'll see what I said when I was talking about where there's no statement of claim in there. But also, if you're acting for the caveator, anticipate a Section 127 application for removal, and make sure your evidence is, that when you're dealing with that you put sufficient evidence before the court to answer the, to establish a case that you've got an arguable proposition for relief, for equitable relief at the end of the day. If you can't do that, you'll end up, not even the best worded caveat that says a constructive trust, an equitable interest pursuant to a constructive trust, blah, 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 is going to save you if there's not evidence, sworn evidence in an affidavit that sets out the basis upon which you say you've got that. That's why you'll see, if you read Oricchio, you'll see why they lost. Even though they all agreed on what the law was. Are there any questions? What about you, Regan? You still there? Got a question up there? Or have you logged off about 5 minutes after I started?
I'll tell you whether he's on. He's still there.
Is he?
He's typing.
What is it?
I don't know. There you go.
Very long question.
We are all good in...
Thanks, Judge. We're all good here in Toowoomba.
That's it. I was expecting something a bit more intellectual than that from you, Regan. No one else? I'll be like the auctioneer. First call, second call. I think everyone's wanting a drink and something to eat.
I don't want the drink, but I want food. If everyone's here, join me in thanking Mr. Thomas.